Welcome to Behind the Neon Lights, Understanding Personal Injury Law in Las Vegas and Beyond.
Welcome to Behind the Neon Lights, Understanding Personal Injury Law in Las Vegas and Beyond with C. Jared Clark, owner and founder of Clark Law Group. They specialize in auto collisions, motorcycle crashes, and personal injury law, and they're dedicated to helping clients every step of the way. My name is John Clements, and today's episode is Litigation versus Settlement, what every client needs to consider. So Jared, welcome to the podcast.
Good afternoon. Thank you for having me, John.
Yeah, let's talk about what are the key factors that clients should consider when they're trying to decide between, do I pursue litigation or do I accept the settlement offer? Like, what does that decision look like?
Yeah, so that could become very intertwined. Oftentimes it depends on one, what the client's main objective is, right? But there's a lot of different factors, right? One, I like to tell my clients, litigation is going to take a long time, right? So if time is very important to you or time is of the essence, or maybe you have some things that you need to take care of, right? And your case being around another year or two, or maybe 3 years, which is very practical, that may influence whether or not you want to resolve your case, depending on what offer is on the table, right? Litigation also comes with what's called additional costs, right? It costs money to file a lawsuit, right? That comes out of the settlement. It costs money to serve the other party. It costs money to retain experts and hire arbitrators or mediators when it comes to trying to prosecute your case. So always take a cost-benefit analysis when it comes to how principled are you? Is it about you having your day in court and your story being told, right? Sometimes that's exactly what the client is looking for. So there's a lot of different factors that influence, should you settle, should you not? So much of it comes down to, what exactly is the client looking for, and asking those right questions to make sure that you elicit that.
Yeah, it's funny to me. So many questions in life come down to time and money. It's just amazing.
Yeah.
And I would say too, I would assume that the strength of your case is also going to play a part in whether you should litigate or accept an offer. So can you just talk to us about that a little bit? Like, how do you assess the strength of a personal injury case?
There's a ton of factors that go into that. One of the main ones, right, is how consistent were you in your medical treatment? Were these huge gaps in treatment, right? Those are things that the insurance company, and when a lawyer gets involved on the other side, they're going to try to use those things against you. Was your treatment complaints inconsistent many times, right? You're telling one doctor one thing, you're telling the other doctor something else. How good of a historian are you, right? As much as sometimes that we think that shouldn't matter, the truth of the matter is it does matter. The other side is going to look to diminish your credibility any chance they could get. Are you very forgetful, right? How well do you present? When they take your deposition, they're really concerned with how would you present in front of a jury of strangers, right? Are you going to be sharp? Do you present well? So there's a lot of different factors that comes when it's time to assess whether or not, hey, you're going to be a great candidate for litigation or you're not going to be a great candidate for litigation based upon the offer that may be on the table.
Yeah, that's really interesting. I didn't think of all those different aspects of the strength of the case, from like how you present yourself to like how good is your memory. And so now it's making sense to me. In the previous episode, you mentioned, having a diary of what happens after the accident, how that can play a part. Just a lot of really interesting ideas there. And then we talked briefly about it, but, going back to the time and money idea, like how much does time and money come into play when you're trying to decide whether to litigate or settle?
Yeah, the reality is both are very important. And ultimately, that's usually what it comes down to. As I mentioned, it costs money to litigate a case. If you want your lawyer to properly present your case, make sure you have all the right experts so we could get you the justice or the settlement or the verdict that you deserve. It's costly, right? Now that comes out of the settlement, and that's up to us to make that decision on whether or not we believe we're going to be successful and recouping that plus a lot more to make it make sense, But there's a time value to money, right, to everybody. And I always try to elicit that from my clients is what is the value of time to you, right? What is that monetary value, right? If I tell you, they're lowballing your case or they're undervaluing it by X amount of dollars, here's what we're going to have to do, whether it be around another year or two, consider potential appeals if we go the distance, the cost that we have to put into it. What does that mean to you? Also the uncertainty that's built into that. as opposed to, hey, here's the offer on the table. I do believe it's fair. I believe it's worth a little bit more, but this is satisfactory to me. This feels like justice was still served.
Yeah. And actually, I want to dig into that as well, because this idea that, okay, I feel like justice has been served, like that's important. That's important to people. So talk to me about these psychological aspects of litigation versus settling, and how that kind of affects whether a client of yours wants to continue or not.
Yeah, litigation is very emotionally taxing. It just is, right? You have the other side, right? The attorney and the insurance company trying to cut your legs off every chance they can, right? Trying to make you to look like this liar every chance that you can, trying to undermine anything that you're saying, right? In these depositions, it's uncomfortable, right? And frankly, who wants to have to answer to that? That's how the civil justice system works when there's an impasse and we're trying to get you justice on your behalf. But it's an uncomfortable process. And sometimes anxiety and or depression, the uncertainty of it all, that's all that comes with litigation. So those are additional factors that you have to consider when you're thinking about court, because it is completely different than what we call pre-litigation or the claims process. And I try to be as candid with my clients as I can of what that entails, just so one, they're properly prepared and they know what battle they're signing up for.
Yeah, and that's very interesting to me, because you've got, on the one hand, okay, if you walk into the courtroom and we start litigating, this is how you could be treated. And on the other hand, everyone involved no doubt wants to see justice served. And so how do you counsel someone who comes to you and says, well, I want justice served, but I don't want to go in and be treated like that in a court of law? Like, how do you help them make a decision?
As I kind of explain the pros and cons of everything, I always take it, and this is what I do. It's a righteous approach. I am naturally principled. I think that's what the civil justice system is there for, because if not, you allow the other side to kind of bully you at times, right? And that's why we represent the victims against the big $1 billion corporations, because we're not going to stand for that. Right. So I try to explain to my clients, yes, we are seeking monetary damages. That's how the civil justice is set up. But also, this is an integrity thing. This is a pride thing. This is making a wrong a right thing. And here are the tools that we have to do it. And, this is what it looks like. Let's sharpen these tools and go to war. But this is what you're going to be looking at.
Yeah. So basically, you're letting your clients know that you have their back at all times.
Always.
Yeah.
Always.
So let's talk about it a little bit, because that might be a misconception some people have, that lawyers aren't for them, when in fact a lawyer like you is for them. So what other kind of misconceptions do clients bring to this litigation process that might affect their decision?
Sometimes you get that from clients, right? And it's like that's the sole purpose we've been retained, right? Is to advance your interest, to make sure we're doing the right thing by you. One of the misconceptions sometimes, despite how many times you tell a client, is that litigation is not going to be long, right? It's somehow going to be short. Sometimes getting halfway through the litigation process and the client getting frustrated, which is completely understandable. But reminding them, one, what they signed up for, and two, we got to finish the job, right? Not quitting. Those are some of the things that I've noticed with respect to clients' misconceptions or just kind of concerns as the litigation process moves forward.
Oh, so that's an interesting question. As let's say I'm your client, and I say, okay, we're going to litigate this. I want justice to be served. I'm willing to put up with all the junk. And I get about halfway through and I go, you know what, Jared, I think I don't want to put up with this. Is there an out, or am I committed at this point to go all the way?
Well, there's always an out. That question is bundled. There's a lot of answers in that. We work for the client, so a lot of the large decisions are ultimately the client's choice, right? To file a lawsuit or not file a lawsuit. We don't make that decision, right? Our client makes that decision. To accept the offer on the table or not accept the offer on the table. Our client makes those decisions. So, ultimately, if it comes, where we're 6 months in or, 50, 60% through, right, the clients, they do control those large decision-making processes.
Okay. So they might decide at a certain point, I'm good. Thanks. We'll just take what's on the table and we'll walk.
Yeah, they may do a, their cost benefit analysis at that time and what that looks like for them. And I say, hey, this settlement offer and this is causing me stress or anxiety and,
Hmm.
proceeding forward. This just has been around too long. And that happens at times. It does.
Mm. And is that something that you would then, talk through with the client and then support whatever decision they came to?
Absolutely. I would just, keep them informed what it looks like if we stop here, what it looks like if we continue going, and,
Hmm.
then give my professional recommendations. But ultimately, I'm going to support them in their decision because it's their case.
Nice. Yeah. And there's something I want to go back to what you said earlier about you represent individuals oftentimes against large corporations. What's unique about that as opposed to like just an individual versus an individual case?
Yeah. So, well, and when I say that, I mean, going against a corporation. So let's maybe say FedEx or Amazon caused the
Hmm.
incident, but the real person holding the money or kind of interfering with us getting justice for our clients are the insurance companies, which are corporations, right? So although their insured may have caused the accident, it's the Geico and the State Farms that's holding the bag, for lack of better words, right? So, it's the David and Goliath analogy that I like to use where, we represent the little guy against the big guy, right? And the big guy has caused this wrong, and it's our job to make it a right with the resources that we have.
So, what are some of the tactics that a big insurance company might use that you would have to counterattack?
I think tactics is the perfect word, right?
Okay.
I think it's very fitting, right? I would use it. Insurance companies have billions and billions of dollars, right? And we know money in a lot of spaces can and does move the needle, right? So when it comes time to hiring experts in certain things, we're never going to be able to outspend an insurance company. It's just not going to happen, they have money that can last for a year, 2, 3 years. So, they could drag a case out. And as we just got done mentioning, in the last couple of questions of, somebody's case being around a year, 2 or 3 years, and the client getting frustrated with that process, right? Well, if they're not putting reasonable offers on the table based on the client's facts, that's another a tactic to delay and or deny. Early on in the case, when it comes to hiring experts for their experts to, compile data in an effort to try to undermine their claim, right? Or insurance companies knowing that there's a big injury and they try to have the client settle before they could talk to a lawyer,
Mm.
right? Knowing that there's a huge fracture there, they might have the client settle for $500 or $1,000 when they know those cases are valued higher than that, and they try to get to the client prior to the client speaking to a law firm. So there's a lot of different tactics that they do to either delay the case and or try to undermine or deny the claim.
And for you for responding to those is a lot of it just knowing in advance what these things might be and like having game plans ready to go.
Yes, it's being prepared early, being prepared very early. Like I mentioned, getting your experts lined up early, having a sense of urgency on everything that you're doing, right? If there's surveillance involved, contacting the gas station or the casino to make sure and they preserve that, right? Because a lot of times that footage every 30 days it disappears and you're not going to have access to that. So getting that letter out early. So there's a lot of different things depending on the particular facts of that case that could help, kind of stop them in their tracks or, as the case is being prosecuted.
Okay, so it sounds to me like if I happen to find myself in a situation in the state of Nevada where I am thinking of needing to settle or litigate something, my first call after I've assured my own safety and health is to call you.
Absolutely. Yeah, you're going to want to call a lawyer, call Clark Law Group in particular, right? And, we can make sure and do our best to put you at ease, start to coordinate some medical care for you to make sure that you are not doing anything that may jeopardize your case and you're just unaware of it, maybe providing a statement to someone that you don't need to provide a statement to, oftentimes the mistakes are innocent. And it's just because the clients or the victims don't know that they're making these mistakes.
Yeah, I think like I'm just even learning right now like how ignorant I really am and how I really should call you next time.
I'm a firm believer at, whatever someone does, if that's their expertise or they're kind of their niche, right, to call and ask some questions. And then again, all we could ask for whenever we're making a decision is to be informed.
Yeah, absolutely. So let's end with a couple more questions. I am curious to get your thoughts on this. In your experience, having done this for a number of years, what are the benefits and drawbacks to, say, settling a case early versus waiting to go to a trial?
When it comes to litigation versus kind of settlements here, really what you're looking at are a few things, right? One is the uncertainty in it all. I'm born and raised in Las Vegas, right? I don't gamble, but we know a lot of people gamble here in Las Vegas, right? And when you go the distance, oftentimes it could be considered a gamble to a degree, right? And what I mean by that is you're leaving the fate in jurors that you don't know, effectively strangers, right, in their hands, right? And depending on what venue or what jurisdiction you're in, some may be more conservative than others, right? Some may be more liberal. All that is going to oftentimes impact what decision they're going to make, right? What views are they going to have? What moves the needle for them and their family when it comes to certain facts on your case, and is their verdict going to reflect that, So jury trials and arbitrations, they are great, right? But they have their drawbacks. And then oftentimes, they have their value system, right? Where the jury could come back and award a great settlement because the client really spoke to them or their story really spoke to them and everything was compelling, But there are times where a case should go to trial and there are times where a case should be resolved. It really just varies.
Nice. And so that's, again, all the more important to call someone like you to get some good advice on which one you might have. And
Correct.
So then, yeah. And so the last question for you today, how do you handle settlement negotiations on behalf of your clients?
Settlement negotiations, things that move the needle, at least for us, or my personal opinion of settlement negotiations is one is being prepared, right? What I realize is a lot of adjusters, they have these kind of, and the adjusters are the folks who work for the insurance companies who are adjusting the claim. And they have these just normal paradigm on every single case, right? So oftentimes they're not really looking at whether or not it's a permanent injury. They're not looking at the MRIs and really understanding the medicine behind things, right? If it's an invisible injury like a traumatic brain injury, I realize part of our job is educating the adjuster on exactly what is going on. They have a job to do. A lot of times it's their higher ups telling them, hey, put this offer on and this computer prints this out, the whole nine. So, trying to share the human story, right? There's a great trial lawyer, Nick Rowley, who is just a phenomenal trial lawyer who gets these nuclear verdicts, right? He has this concept of trial by human, right? And that's making sure that the adjuster or the jury or the attorney on the other side understands the human harms that have affected your client, and that human story is always pretty powerful.
Yeah, agreed. Well, Jared, it's been a pleasure talking with you today. Thank you so much for all the wisdom and information you've provided.
Thank you for having me, John. I appreciate it.
Yeah. And to our listeners, thanks for tuning in to Behind the Neon Lights, Understanding Personal Injury Law in Las Vegas and Beyond with C. Jared Clark. To connect with the team, head to injuryattorneyvegas.com. And as always, leave a like, subscribe, and leave a review if you liked what you saw. And with that, have a great day.
Awesome. Have a good one. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.